It was nice to see a Monday morning piece of political good news, at least good news if you're a fan of the Constitution and a faithful reading of it, and just plain old sanity from the Supreme Court in upholding it. Back in February, I did a video about a case called Caniglia v. Strom. You may recall this was the case of a man who was reported to the police by his wife as dangerous and armed. Police came to his home and convinced him to check into a psych hospital. He did that voluntarily. And then after he went to the hospital, police went back into his home and seized his firearms. Police had no warrant. The man committed no crime. The man had no violent or criminal history. But police took his property and disarmed him anyway. My full video on the facts of that case is linked below if you want all the information, but even based on that limited description, you might wonder how that could ever be constitutional. That sounds like an unconstitutional blooming onion, with layers upon layers from which to pick. Warrantless entry of the home, warrantless seizure of property, infringement on the right to bear arms. The state's argument in the case was for the expansion of the so-called community caretaker exception to the Fourth Amendment. Yeah, sure, we went in your house, and sure, we took some of your property, and sure, we disarmed you, but we didn't do it as part of some criminal proceeding. We did it because we were just being really nice and looking out for community safety. You know, just like a good neighbor. See, as long as the police are helping an old lady cross the street while they're violating your rights, they're just looking out for the community. They morph into the Boy Scouts, and it doesn't matter if they have the Constitution dangling off their boot like a piece of toilet paper while they're stealing your property. That sounds overstated, but that was effectively the state's argument, and it's an argument that won on its appeals through the court system. And the hope was that the Supreme Court agreed to hear this case to correct that obvious mistake, to state strongly, no, the Bill of Rights still has clear meaning, and you can't just invalidate it by claiming to be a nice guy and looking out for your neighbors. But of course, these days, hope frequently descends into cope. So I've been watching this case with only cautious optimism that the court would get it right. And they did, actually. That was Monday's great news. The court didn't just reach the correct constitutional decision, they did it unanimously. This case was such an affront to the Constitution that the ideological wings of the court were erased. In writing the decision, Clarence Thomas just copy-pasted the Fourth Amendment and acknowledged some exceptions do exist, but these exceptions must be narrowly defined and strictly limited. They are not an open-ended license to perform this sort of warrantless search and seizure anytime, anywhere. And in a smaller detail, it wasn't just a unanimous defense of the Constitution, it was also a unanimous rejection of the position of the White House. The Biden Justice Department filed a brief and gave the court statements in favor of this constitutional shredding, arguing that the primary principle at stake in this case is not a Fourth Amendment one. It's that if the state thinks there's a risk or danger, they must be able to intervene now. So create the emergency and delete your rights. By now, that should be a familiar script to you, but at least as of Monday, that script has fewer lines. The hope that the court took that case to stand for the Constitution came true, and at least for the day, the Constitution finally got a win. And now, the next question is, was this case foreshadowing? Was it part of a forthcoming trend? You can always assume that the court takes any given case for a reason. If the court was intent on simply upholding prior case law, there wouldn't be a reason to take that case. And with a new majority philosophy on the court that's commonly called conservative or right-wing, more accurately, constitutionally faithful, or at least something closer, is the court prepared to restore the Constitution in other areas in which it's been abused? That was Monday's bigger news. The court has accepted a case that will directly challenge the core reasoning of Roe v. Wade and subsequent abortion decisions. Arguments will be heard in the fall, with a decision likely issued about this time next year. To understand the reasoning this case will challenge and the questions the court will answer, we need to back up to the court's precedential cases, Roe v. Wade and Planned Parenthood v. Casey. How is it that there's a constitutional right to an abortion when the Constitution mentions no such thing? Well, to answer that question, it's just a brief intellectual tour through imagination land. According to these cases, the right to an abortion falls under what's called substantive due process, the idea that the 14th Amendment's due process guarantees aren't just rights in legal proceedings, they're rights that include a whole host of penumbras of social liberty, one of those being privacy. And if privacy is a due process right under the 14th, then a woman has a right to the privacy of her abortion, at least early term. And if that sounds like confused, labored reasoning, that's because it is. To this day, it is still the only context in which I ever hear the word penumbra. If it doesn't make any sense, just give it an academic-sounding vocabulary word and trust that the peasants are too stupid to understand it. But if we accept this reasoning, a lot of questions still remain. If the court can just insert new rights into the Constitution, what are the limitations, if any? Is a penumbra just a fancy-sounding umbrella to cover the broad range of stuff I like and give it untouchable constitutional protection? And even if privacy is a constitutional penumbra right, how does privacy extend to abortion? If I murder my neighbor privately with somber decency in a closed-door medical setting, is that penumbra protected privacy? Depends on what your definition of a life is. And that is where the court had to go next. See, it wasn't just that the post-Civil War ratification of the 14th Amendment was actually secret code for abortion protection. It's that the authors intended a specific federally mandated time framework for when this privacy penumbra expires. According to the Roe decision, in the first trimester, all abortions are penumbrified, untouchable by any regulation from the state. In the second trimester, the state can apply some health regulations, and in the third trimester, since the fetus is viable or capable of surviving outside the womb, the state can ban abortion outright. And just like that, they did it. They cracked the code of exactly what those Civil War amputees were thinking when they wrote the post-war amendments about slavery and citizenship. But it turns out it wasn't perfectly decoded just yet. The message still needed just a little tinkering. In the subsequent case of Planned Parenthood versus Casey, the court scrapped this trimester framework in favor of a simpler viability standard. Before a fetus could survive outside the womb, the decision on terminating the pregnancy is solely the woman's. After that viability point, then the state can intervene. And the state is also prohibited from instituting any pre-viability undue burdens on abortion. In plain terms, these are ways of making abortion access more difficult. What is an undue burden, and how could it possibly be constitutionally defined when the text of the document mentions neither word? Courts have been wrestling to answer those questions in the 30 years since. And additionally, what is viability? How is viability defined? Do we mean the average time at which fetuses become viable, and according to whom? According to one doctor? According to a broad poll of doctors? Do we mean when just that individual particular fetus becomes viable, it can't be aborted? Or just most fetuses in general? And what about medical technology? Viability is earlier today than it was yesterday. And tomorrow, it'll be earlier still. What does viability mean? The Supreme Court has never decided. And that is the question the court will address in this new case. It comes from Mississippi, where state lawmakers in 2018 outlawed most abortions past 15 weeks. This is likely to be a significant decision addressing the substance of the viability reasoning, not some technical sidestep like we often see. The court has agreed to address only the question of whether all pre-viability abortion bans are unconstitutional. As far as possible outcomes, even with the court's presumed new skepticism of Roe and Casey's reasoning, how deep that skepticism runs is still unknown and will be tested. This case has the potential to overturn that viability standard outright, potentially even the supposed constitutional right to an abortion outright. But I think those outcomes are unlikely. Much more likely, in my opinion, is the court keeps that viability framework and just gives it some more specifics, some definition for what viability means, how it's defined, who defines it. And then Mississippi's law will be judged according to that standard. But it's those questions, who gets to decide and according to what, that are actually the core questions of the constitutional abortion issue. The issue is too often framed as simply one about abortion rights. If you're in favor of abortion rights, you're supposed to be pro-Roe. If you oppose abortion rights, you're supposed to be anti-Roe. But at its core, this issue actually isn't about abortion opinion at all. It's an issue of procedure and jurisdiction. It's not about what the decision is. It's about who gets to make it. The core flaw in Roe and Casey's reasoning is not that abortion is good or abortion is bad. It's that those decisions were made without respect for the system whereby political questions on which the Constitution is silent are to be answered by the states and by the people, not by federal edict. If the Supreme Court can simply decree law by which we all must abide, then our systems of state autonomy and representative government are dead, and there's no penumbra that can make them viable. The Supreme Court is not a faithful arbiter of the Constitution in that framework. They're just 9 unelected kings who can rule us all by their whims. And just because you like the Royal Council's decree today doesn't mean that you'll like it tomorrow, or that you should grant a National Council of Unelecteds the authority to rule over you or your state. For the supposed pro-choice movement, that is as anti-choice of a government structure as you could possibly design. Even if the court outright erases Roe and Casey this time next year, you don't lose any right to choose whatsoever. You and your state will still answer this question according to your own moral conscience. And yes, California will answer the question differently from Alabama. That's true. But neither state holds you captive. In the same way, you can leave California's oppressive taxation and regulation. You can leave Alabama if you find offense in their unjust intrusion on your recreational killing of your offspring. That broader right to choose has always been constitutionally protected by the framework that the states and the people, not federal overlords, hold power. But the betrayal of that system has ironically claimed the title pro-choice while empowering a central authority to make one choice for everybody. Even if you are pro-choice on the abortion issue, there should be nothing wrong with claiming that choice back for yourself and for your state. On these principles, we should all agree. But of course, looking for principle in a pink pussy hat is about as foolish an errand as they come. I think these are the claws with which they scratch the Constitution. Thanks as always for listening and for supporting this channel. Always appreciate that thoughtful discussion down below, and especially over on Gab, that is at ML Christiansen. You're always welcome to coming out and chat in my live streams. Those are linked down in the description. Looking forward to it. Goodbye.